Hi, I'm Debbie Moraes. This is Legal Matters, the program that's been designed to address timely, critical, and sometimes contentious issues that are facing businesses and consumers today. Legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. We want to begin by thanking our legal counsel and our sponsors of this long-running program, the law firm of Bazar, Grasso in East Providence, and attorneys Jacqueline Grasso and David Bazar, who is with us. Welcome.
Hi, Debbie.
So today, privacy, actually privacy protection. The Fourth Amendment to the U.S. Constitution places limits on the power of the police to make arrests and to search people and their property and to seize objects, even contraband. So those limits are the foundation, as David will explain more, about the search and seizure law. And I think a good place to begin is the bottom line of what has become a very highly controversial news headlining recent issue. It is the bottom line, a sweeping endorsement for privacy rights. So the Supreme Court, somewhere in the middle of June, voted unanimously, ruled unanimously, that the police may not search a cell phone of a criminal suspect upon arrest without a warrant. So what can they search? When can they search? Under what circumstances can they get to your phone? How about your tablet? What about your laptop? And notwithstanding, in the broader picture, what other limitations on searches? By your employer, by Facebook, by the NSA, by your schools, and what's the flip side? So there's lots to cover. Let's get to it. Okay, at the beginning, David, the big issue, the big topic in the news was this ruling by the Supreme Court. They can't take my cell phone without having a warrant. How does that work?
So let's start at the beginning. What constitutes an unlawful search and a seizure, and where does that protection come from? The protection comes from the Fourth Amendment of the Constitution. And the Bill of Rights, the first 10 amendments, when the Constitution was passed, have a whole host of protections that you all cite day in, day out. I know you do. The First Amendment, you know, the right of free speech and all of the rights that flow from the Constitution that protect us. So now we're dealing with the Fourth Amendment and the protections against having things searched without a warrant, really is what it comes to. And then a whole lot of exceptions that flowed through the courts in time after that. So what we're dealing with here was whether or not the courts would require, again, what would be an exception to your constitutional protections against unlawful search and seizure by letting police search a cell phone. And the court found that there is no reason to allow them to search a phone without getting a warrant, because a phone is much like a computer these days. All the information that you have stored on it is your private information. There's this reasonable expectation of privacy that somebody would have to the information in their phone, and therefore the court requires the police to go to that independent arbiter, the courts, to determine whether or not there's probable cause for them to search a phone.
And the cell phone issue blew up because, I guess you'd say, when is a cell phone not a cell phone? A cell phone holds my banking information, my drug use, my legal or otherwise. It holds my life. And is it just because it has such a vast storage capacity of private things that the police don't have access to, even if they wanted to search for one thing? Now they get to have rampant access to everything. Is that why the cell phone became a very big issue?
Exactly. And it's, like I said, a mini computer. So you have all sorts of information on there, the contacts, the people that you speak to, that you have stored in your phone, the telephone calls that you make, and the information that you would have a reasonable expectation of privacy in. And therefore the courts held, just like if they were going to get your records from the telephone company in the old days when we had those phones with the rotaries.
Dial.
Yeah, and you actually made phone calls from home out of those things, and the companies would keep records of who you called. Those records would have to be subpoenaed by the court or by the police, or a warrant to get them from the company that stored that information, so to speak. There's an expectation of some privacy in those things, and the phone expands all that today with the capabilities of all of the information you can store on it and use it for.
So
just, pictures and things of that nature you might have on there. You would not expect that someone could just come in and look at what you have stored privately.
So the issue is about the cell phones, David, but if someone is arrested and it's not the cell phone, but say it's their tablet or their laptop, same?
I would argue it's exactly the same, because the tablet has the capability of keeping all of that private information on it, so therefore the reasonable expectation of privacy exists. The computer would have it. What other thing?
Laptop, tablet.
Computer. Yes, all of those
same.
things would be the same.
And what about the idea of it being in a public place? Suppose they want to arrest someone in a public place. It's nothing to do with the fact that it's in a public place that they want to confiscate something that's personal. It still is about the person's private property that they don't have access to. Is that correct?
It's about that phone or tablet or laptop containing private information. The fact that it's mobile and can be in your pocket and you can take it from place to place is sort of irrelevant to the reasoning that goes into the decision as to determining whether or not you have the reasonable expectation of privacy, and therefore is it reasonable to have the police, law enforcement, take that extra step of getting a warrant before they look into it.
So this, as this unfolded, there were two cases. One, I guess it's in California, one in Massachusetts, where there was appeals. Obviously, when the police seized the cell phone information, they got more than they bargained for. Or maybe that's what they were hoping for, and apparently they had, on appeal, it ended up going to the Supreme Court, and this blew up. How about all of these poor people who have been, and currently are, serving prison sentences because they did have their property confiscated, including that cell phone, which then served up as evidence on a platter to whomever wanted to go after them? Do they have recourse now?
Well, it really depends on the facts of that case and whether or not the evidence that was taken illegally. If we now determine that a warrant was necessary, and that that evidence was the nexus or crux of whatever information was used to convict them. The sort of the fruit of the poisonous tree kind of thing. If the police had no way, or law enforcement had no way of getting the information they needed to convict somebody, there might be grounds, although you could also argue on the other side that that should have been raised at the time of the trial, and it's not like DNA evidence that's found afterwards. You could have raised that as a defense right from the beginning.
But if there weren't a Supreme Court ruling, it wouldn't have stood. They would have been able to defend it, or would they not have?
Well, you could have raised it on your own, and you could have been the case that went to the Supreme Court.
Good to
so
know.
It's very possible that they could determine that, no, this is not now grounds for an appeal because you didn't raise it. And appeals require that the issue be raised in the lower court before you raise it on appeal. You can't just raise something new on an appeal that you didn't raise before. So the question is whether a motion for a new trial might be considered and whether there's grounds for that.
Good to know. That's one of the finer points that in all of the reading, I don't believe that was uncovered, although there was some discussion about whether or not retroactively there might be a new set of appeals.
Yeah.
So predictably now, law enforcement is supposed to toe the line. They're supposed to comply, but they're not giving up that easily either. Understandably, they want to assert their rights, and they refer to something called exigent circumstances or some other applicable exception so that they can circumvent, not have to have a warrant at the time. And that was one of the first reactions from some spokesperson from the Justice Department. How burdensome is it for somebody to get a warrant? I understand that it's not that difficult, so why can they just suddenly say there's an exigent circumstance?
It isn't difficult, and the exigent circumstances argument has been raised on many different occasions for many different issues, and on occasion you could argue that there are reasons for that. For example, you're allowed as a police officer to search an automobile, the automobile exception. And there's two things I think that go into that. There can be exigent circumstances, whether or not there's a weapon or something to be concerned about that could be in that automobile. And two, and this goes back to the argument that was the other side of the coin for mobile phones, for example, is there's a lower expectation of privacy for the contents of what's in your car than there are for the contents of what's in your mobile phone.
So it's not about it being in a public place, and it's not considered my personal private property that they can't have access to without a warrant?
Well,
if it's in a car?
In an automobile, the courts have held that there's a lower expectation of privacy because you drive the car in public. You don't usually drive the car around your driveway back and forth to nowhere. And so that because you're taking your car out in public, the lower expectation of privacy exists, and therefore, since there's a lower expectation of privacy and perhaps exigent circumstances that could exist, they allow a search of your automobile without a warrant.
Let's continue that then. You refer to the car. How about if you happen to be on a bus, a train, a plane, and a subway? Would that apply too?
Well, the stuff on the bus, the plane, the train, and the subway, except for the little bit that you bring, isn't yours. So now what you're saying is, can they say, I want to search your bag? And the answer to that, I would argue, it depends on the circumstances. But for the most part, there is some expectation of privacy on what you're carrying in your bag on a plane or a bus or whatever. However, just going on a plane, gives the airport authorities the right to search your bag and go through it because of those circumstances. You waive that right when you get on a plane. And certainly, if you're taken off a bus and you're being arrested, there's a thing called a Terry touch, which is when you're arrested, they're allowed to pat you down. All right?
Okay, that's what it's called.
Yeah, so that's from a case, I think it must have been United States versus Terry or something like that, because they call it the Terry touch. And there's reasons that police officers and law enforcement have to protect themselves, and one of the things they're allowed to do is to touch a person, pat them down to see whether or not there's any weapons or whatever else they might be concealing.
To play the devil's advocate for a moment, why couldn't a police officer say, I think I might have been in danger, so I had to search him, or I think that that phone could have been used, as they're thinking now with computers, might be a detonator for something, or I have a reason to suspect that they may be hitting a cell phone button and destroying all of the evidence. How do you justify that, or how do you explain that away?
So those issues come up all the time.
Yes.
In all of these other circumstances that have been in the forefront well before cell phones and mobile devices of any type. So the answer to that is the judge has to look at the circumstances, and based on what is the condition of the person who owns the phone. Are they handcuffed? Are they being questioned? Do they have access to the phone? Do they have access to another device to wipe what's on that device? Once you look at the totality of the circumstances, a judge can determine whether or not the police officers are acting in a reasonable manner.
So isn't it easier to say, oops, I'm sorry, afterwards, and try to prevent the loss of information or an opportunity to get information that you want, even in a yet undiscovered, that's not fair, but a yet undiscovered crime? Wouldn't it be better to take your chances, scoop it, and say, defend it later by saying, gee, I think it was very likely that that person who was acting badly, behaving erratically, was probably on drugs, so of course I had good reason to search or pull something from their bag or whatever.
Yeah, you really have to be able to defend the probable cause. That is your reason for acting. I think one of the examples I might go to is where the police officer goes into a home without a search warrant because they believe there's imminent danger to somebody in the home. If they have a valid reason for thinking that and can defend that in court, then the entry into the home without a search warrant isn't going to invalidate whatever they find as long as there was probable cause and an exigent circumstance. Without that, and without being able to defend that, most judges would probably throw out whatever evidence you found. So be careful as a police officer to act with care and within reason.
And if you happen to be the poor soul who is arrested, let's hope that because it's in the media that more and more people say, excuse me, officer, you don't have a warrant, or do you have a warrant before I fork over my cell phone, laptop, and tablet? What exactly would you advise someone who's arrested to do? Would you say, excuse me, you don't have a right to my cell phone and I want my attorney and please leave me alone?
Right. Assert your right to an attorney. This is as a defense attorney speaking.
Yes, okay.
Assert your right to an attorney. Don't give them the password to your phone. Hopefully it's password protected so that they don't go into it. And object to them going into it if you see them doing that. Of course, do so at your own peril if you're in a police station doing that. But if there's no exigent circumstances, then they should not go into your phone. Now, I can think of a lot of grounds and reasons where they would. If they think there's information in there that they need to find somebody to save somebody's life that they know is in peril, and they have reasonable grounds to think that it's in there, then by all means they should do whatever they can to get in. But if it's just a fishing expedition, so to speak, then they should wait till they take the proper time to get a warrant.
And that could be as much as a phone call away, which could be done over the phone, I assume, or not done over the phone, but at least authorized, right?
Yeah, and a lot of times there's judges on call who police officers can swing by, give them the affidavits and all the information, and they can sign off quickly.
So with this news about if you happen to be arrested, that they don't have access to your cell phone without a warrant, what happens if you are just stopped? That would make me think, of course, that they have even less right to search, seize, whatever. But suppose they say to some unsuspecting person, it'll be much better for you if you just cooperate right now, so you have nothing to hide, right? So you should just pass it along. If someone's only stopped, their taillights out, I don't know, or they were speeding and they need a ticket, but they don't need to be arrested. Do you say to that person, if you are the defense attorney, you absolutely should not give them a thing because you are not forced to and should not?
I always say, assert your constitutional rights. You have the protection for a reason. Assert your rights. Now, remember I said with an automobile stop, there's the automobile exception. If they have reasonable or probable cause to search the car, they can search the car and the contents of the car. So that can happen. But one of the things with this new case that I would argue is they can't do is search the phone. So, yep, I have a phone. Can I look at it? No. Why are you pulling me over? Did you think I was texting while I was driving? I was looking at my GPS on my phone. I'm sorry. Well, I would like you to show me that. Well, if you don't show them that, they're probably going to give you the ticket for texting, but that's their prerogative because they have probable cause or reasonable grounds to do that because you were looking at your phone, but you do not have to show them your phone.
And of the things that they could easily defend, even if you were stopped, suppose they have as their defense, speaking as if I were supporting their right to do what they need to do. I have a very good, very strong feeling that they were likely to destroy some evidence, so I needed to search, I needed to seize that right now to prevent that from happening. How do you defend that? I mean, how would you as a defense attorney counter that?
What's the basis for you even asserting that they're going to destroy evidence? Give me a basis for that. Now, with the phone, if there's information in the phone that they want to get, I would argue that the police officer has every right to hold the phone, not go into the phone while they're getting a search warrant.
Good to know. What about these loopholes, though? I understand that the police need to do what they need to do, government officials that are ready to protect me, NSA included. In the name of what they need to do, it seems that the ones that I've mentioned to you, whether it was destruction of evidence or it was a matter of safety, does it not seem that even with this ruling that there is plenty of leeway for the government protecting us, certainly has plenty of latitude within which to operate? Whether they get a warrant or not, they can certainly say there was a loophole, I need to prevent destruction, I was in harm's way, somebody else was in harm's way. They certainly have a lot of latitude.
Right. There is a lot of latitude. And so just talking about the holding of the phone thing I was talking about a minute ago, it's just, to me, the same as they have a right to hold somebody while they're investigating a crime, to question them, and to investigate the crime. So you can be held by a police officer for a reasonable period of time while they're investigating something. So I think they could hold your phone for that period of time too while they're trying to get a warrant to search it. So the loopholes are many. I call them loopholes. You might call them exceptions. Exceptions to the constitutional right against unlawful search and seizure. And they've been laid out in many other types of cases and in many cases up to date. And there are even more exceptions today, as you know, in the law under national security issues and things of that nature.
go there. That's what I wanted to ask next.
Okay.
Of course, I understand that the TSA is trying to protect, that's a government agency, and they're, of course, supposed to be respecting my privacy, but they also have a bigger fish to fry. They have greater issues to
Right.
deal with. So with the TSA and its airplanes, they get to search anything they want. Most recently, I guess, in the news was you have to start up your computer. If you can't, it's mine, or we
Right.
get to confiscate it. Does that give them the right to look at its contents, too?
And I don't think that's the issue.
Okay.
I think the issue is that the device has to be a real device, not one that's made to look like a device with the insides taken out so that it could contain explosive devices or something of that nature. I think that's what the concern is. So they want to see you start it up and see the phone or the tablet or the laptop come on. They want to know that it's a working device. I don't think it's the software in the device that they're all that concerned about. It's what could be built in the device, such as I understood it, the underwear bomber built the bombs into the underwear, and the shoe bomber into the shoes, so that's why we take our shoes off and that type of thing. They want to know that you're not trying to bring an explosive device on the plane in the form of a laptop or a cell phone or a computer, a tablet of some type.
Makes sense, or a detonator. So I understand that there's a difference. While the framers of our Constitution wanted to make sure that there was not any unnecessary government intrusion. However, apparently there's a difference between the government doing it and, say, a private security company. Not necessarily TSA, because that still represents government, right? But a private security company, they're not held to the same standards of needing a warrant. Does that mean that the security agent at your local mall sees some hyperactive kids and they think that they're possibly doing something, that security officer has the right to seize that phone?
So the constitutional protections are protecting the individuals, the citizens of the United States, against unreasonable actions of the government. So you're 100% right when you say that the protections are against the government or government actions. The individual security officer doesn't have any governmental authority, in fact has no authority to take anything from anybody. So he can protect property that he's there to secure, but he can't arrest you or take your property or seize anything.
He can ask you to leave. Is that it? That's as good as it
Right.
gets?
Right. But what authority at all would someone working in a mall security guy, say as you're walking down, give me your phone? That's stealing.
Right. But he could wrestle you to the ground if there was some sort of a conflict.
If you're creating a disturbance, if you're a danger to other people, that's his job. He can do that. But his job isn't to investigate potential crimes and seize evidence to do that.
Okay, good to know. And while there's been an endorsement for the rights of privacy on the one hand, apparently Facebook, at least so far as we understand right now, they failed in their attempts. Apparently they were challenged by the Manhattan District Attorney's Office to fork over the records of their customers. And could it be argued, as Facebook did, that there's as much private information on someone's social media profile as there is perhaps in their cell phone? But apparently Manhattan DA has prevailed and wants some broad sweeping access to whatever Facebook has as information. And let's face it, they have plenty. So does the Internet. How does that pertain? How do you get to protect a person's rights in that case? Can Facebook do that as an agent acting for the customer? How does that work, David?
So I would equate it to a bank. And a bank is holding your money and the records of your money. So if somebody wants to get those records, they have to subpoena the bank. The information that Facebook is holding, which as you say is even more private, should require a subpoena, whether it's the government or anyone else asking for it. And Facebook should be allowed to file a motion to quash the subpoena and give the person whose records they're being requested notice of that so that they can go in and argue whether or not the subpoena should be allowed to go forward or should be quashed.
Apparently, as Facebook's defense attorney said, we can't even notify these customers because they weren't even supposed to be known, it wasn't supposed to be known in the first place, so how do we let them know that they might have had a potential invasion of their privacy in the second place? But apparently, I don't know if it's stalled, but it certainly doesn't seem that they're going to be winning. But is there some reasonable way that if someone was doing something illegal on Facebook and the DA wanted something, at least does it make sense that they could go to Facebook and say, we have a warrant to get information on Joe Jones because we think he's doing child pornography or something through Facebook? Then it's very narrow and specific. Would that then become a reasonable thing for them to get a subpoena or a warrant for?
Right.
Rather?
The more narrow and carefully tailored the request is, the more likely it would be for a judge to grant it. A broad, sweeping fishing expedition is not reasonable, but if there's something narrow and specific, then yes. Now, bear in mind, Facebook is, as you say, a social media. Most of the records of what's out there is public record anyway, because they can just go online and look at whatever it is. So there must be certain things that are not part of the public record, where there's a slightly more expectation of privacy in those documents or whatever the records are that they're looking for. And therefore, the more expectation of privacy, the more requirements the court should assert before they allow property or things to be turned over.
I guess in Facebook's defense, they do have some privacy settings. I can check a box that says everybody can see all of this. Nobody but the 3 people I select can see that.
Right.
So I'm exercising my right to privacy, and I don't want you to see, perhaps, that I've done something that
right.
I don't want to share. But if the government can, or the district attorney, local government says, I want that, they better have a good reason for it, is what you're...
That's what I'm saying.
Yes, okay. And how about children? They too have rights, don't they? The Fourth Amendment protection. So what happens to kids in the schoolyard, kids in school? They need to be protected, but should they have their lockers searched? Does a private company get to check their laptops and notebooks to make sure that there's not something illegal or contraband?
Well, we've talked about this in the past. And is there an expectation of privacy in the locker? The locker belongs to the school. A police officer cannot come in from the outside and search a student's locker without a warrant. Can the principal? That is a different issue. And if there are exigent circumstances and reasons that the principal wants to search his property, just like I've said before, if you do work at the school on a computer, and the principal or the school looks at the information and stuff that you've used on the school's computer, that is stuff that belongs to the school, and the school does have a right to search and look at those things.
Good to know. And then what about in the workplace, briefly, in the short amount of time we have? Can the employer look at my computer, which is his computer?
The workplace computer that belongs to the employee, you would expect him or her to be able to look at, and so you should use it accordingly.
And my use of my flash drive in my USB that's on his computer, does he have access to look at that if he suspects something, or does he need a warrant too?
If it's your flash drive?
Going into his computer or the work computer?
It's a closer call. If it's your flash drive, what's on your flash drive is yours. If you put it on his computer, it might become his or hers.
One more quick question. My locker at work has my padlock on it. Does he get to have me open that without a warrant?
It's his locker. I think it's a closer call than the school, but you can make an argument on that one both ways.
Okay. We've certainly covered quite a few details and issues about privacy and protection. We hope that it's been helpful to you. We hope that you'll continue to tune in as we discuss more of these issues. Join us next time. Our discussion of legal matters will continue. Join us.